go ahead and float on in. I see that we also just got live on YouTube, so if you want to pull it up there, you're welcome to pull it up there. I'll say welcome back, both to students and to alumni in the audience. I know we had a couple of our alumni reach out and say they were particularly interested in this event, so I'm glad that y'all can join us. Just by way of a couple of announcements, the first thing I'd like to say is mark your calendars for next week at this time. We will be hosting our very own Professor Stephen Collis, a South Texas College of Law Professor Josh Blackman, and Lewis and Clark Law Professor Jim Oleski to debate the merits of the court's decision in Roman Catholic Diocese versus Cuomo and its implications on religious liberty. So that should be a pretty good event coming up next week. That's the last event before spring break. Mike will drop the links for registration Zoom in the chat at some point this evening, so be looking for those. He may already have, I'm not sure. As far as FedSoc Friday's social events go this week, Tanner Baird will have a cigar night at Havana Lounge downtown, so if you're interested in that, feel free to shoot him a text message. Also, Warner Scott and Jonathan Harper are doing a hike at St. Edward's Trail at 2 p.m. on Sunday. So if you're interested in going out for a hike with some FedSoc folks, I think they might try to grab ice cream, true to form, afterwards. So those are notes on the social stuff this week. I'm gonna go ahead and turn it over to Kylie now to introduce our speakers.
So we're delighted to have with us this evening, Mr. Joshua Craddock, who is an affiliated scholar with the James Wilson Institute on Natural Rights and the American Founding. He graduated magna cum laude from Harvard Law School, where he served as editor-in-chief of the Harvard Journal of Law and Public Policy, and later clerked for the Honorable Chief Judge Timothy Timkovich of the U.S. Court of Appeals for the 10th Circuit. Prior to law school, Mr. Craddock managed advocacy teams for several nonprofit organizations at the United Nations and participated in negotiations on the Sustainable Development Goals. His writing has appeared in the Notre Dame Law Review, Harvard Journal on Legislation, the Tennessee Journal of Law and Policy, Newsweek, and the National Review. Also with us this evening is Mr. Ed Whelan, who is a distinguished senior fellow of the Ethics and Public Policy Center and holds EPPC's Antonin Scalia Chair in Constitutional Studies. He is the longest serving president in EPPC's history, having held that position from March 2004 through January 2021. His areas of expertise include constitutional law and the judicial confirmation process, and he's been a leading commentator on nominations to the Supreme Court and the lower courts and on issues of constitutional law. Mr. Whelan, a lawyer and former clerk to Justice Scalia, has also served in positions of responsibility in all three branches of federal government, including as the Principal Deputy Assistant Attorney General for the Office of Legal Counsel in the U.S. Department of Justice, on Capitol Hill as General Counsel to the U.S. Senate Committee on the Judiciary, and in addition to clerking for Justice Scalia, he was a law clerk to Judge J. Clifford Wallace of the U.S. Court of Appeals for the Ninth Circuit. He received his JD magna cum laude in 1985 from Harvard Law School.
Hey, Mike, would you please go on mute?
Yes, sir.
Thanks. All right, so before we get started, I just wanted to say a couple of things about each of these speakers. First, in regards to Ed Whelan, for the future litigators, clerks, court watchers in the crowd, there are very few resources as accessible as NRO's bench memos. If you'd like to keep up with the goings on in the court and in the circuits, it's an absolutely fantastic resource. I would encourage you all to read it regularly. And then as it relates to Josh Craddock, I want to emphasize that he wrote this particular article that we're debating this evening as a student, especially for those of you who are interested in clerking. Don't feel like you have to wait until you graduate to write intelligently and persuasively on topics that matter to you. The journal that Josh formerly led, the Harvard Journal of Law and Public Policy, as well as the Texas Review of Law and Politics, our version of HJLPP, which I have been implored to say is just like 1.5 times better. No competition, I know. But both accept student notes from bright, devoted, young conservatives and libertarians, such as yourselves. So with that said, I'll turn it back over to Kylie. I just wanted to make a plug that we have two great speakers with us tonight.
So Josh's student note for HJLPP arguing that the 14th Amendment provided affirmative protection for the life of the unborn is one of the most downloaded constitutional law papers in recent memory, and it has spurred a video collaboration where he's explained his findings. Recommend you check it out. For many Texas FedSoc members, this was our first exposure to Josh's work, and I think we're all really excited to hear this originalist versus originalist debate. So without further ado, I will give it away to Mr. Craddock to begin.
Well, thank you, Seth and Kylie, for hosting this discussion tonight. Thank you to the Texas Federalist Society for inviting me. It's an honor and pleasure to join all of you in the great state of Texas. And I'm especially glad that Ed is here today, my friend. We've known each other for a few years now, and I'm glad that we get to discuss this topic together. And most of the time when I do these presentations, my respondent doesn't really engage on the originalist question and is more interested in the policy questions. And so I'm really excited to kind of dig into that originalist question today. So just to kind of set the stage, as most of you know, the 1973 Supreme Court decision, Roe v. Wade, required states to allow abortion. The 7 men forming the majority, they determined that the right to privacy includes a woman's decision to end the life of her preborn child effectively through all 9 months of pregnancy. And that decision has been widely criticized, even by legal scholars who support abortion. One of the defining questions of Justice Barrett's recent confirmation hearing was whether she would vote to overturn Roe. I think, at least in the short term, that's unlikely if last term's June medical decision is any indication. But I do think that Justice Barrett's confirmation changes the dynamic on the court, and suddenly the prospect is not so unthinkable. It's worth considering what the legal landscape would be like if Roe were overturned. Now, the conventional wisdom is that reversing Roe would simply return the issue of abortion to the states, and that each state would decide for itself whether to legalize or prohibit abortion. The late Justice Scalia held this view. He wrote in his Planned Parenthood versus Casey opinion that, quote, "The Constitution says absolutely nothing about abortion." In his view, the 14th Amendment's guarantees of due process and equal protection for all persons does not encompass prenatal life. Instead, the question of abortion should be decided state by state through the political process and by democratic choice. In a 2008 interview, Justice Scalia said, quote, "There are anti-abortion people who think that the Constitution requires a state to prohibit abortion. They say that the Equal Protection Clause requires that you treat a helpless human being that's still in the womb the way that you treat other human beings. I think that's wrong. I think that when the Constitution says that the persons are entitled to equal protection of the laws, I think it clearly means walking around persons," end quote. So leaving aside for a moment the observation that if the Constitution only protects walking around persons, it does, by implication, have something to say about abortion. The question I want to focus on is, does the Constitution really only protect walking around persons? Or can one make a plausible counter-argument based on the meaning of the term person as used in the 14th Amendment? So that's what I attempted to do in my article that you were discussing, the Harvard Journal of Law and Public Policy article. It's titled Protecting Prenatal Persons. The structure of my argument is pretty simple. One, the 14th Amendment's use of the word person guarantees due process and equal protection to all members of the human species within the geographic and jurisdictional power of the Constitution. Two, the preborn are members of the human species from the moment of fertilization. And three, the 14th Amendment therefore protects the preborn from fertilization. So I don't think we're going to get too bogged down here on the minor premise that preborn humans are biological members of the human species, but I'd like to stipulate that it's scientifically well established that unborn human beings are members of the species Homo sapiens from fertilization. And actually, a recent survey of biologists found that 95% agreed that human life begins at fertilization, regardless of their view on abortion. And that was actually widely known long before Roe v. Wade. For example, Dr. Bradley Patton of Michigan Medical School wrote in his 1964 textbook, Foundations of Embryology, that, quote, "The union of two such sex cells to form a zygote constitutes the process of fertilization and initiates the life of a new individual." As Dr. Matthews Roth of Harvard University Medical School later said, "It's incorrect to say that the biological data can't be decisive. It's scientifically correct to say that an individual human life begins at conception, and that this developing human always is a member of our species at all stages of its life." But let's put a pin in that discussion and return to what this means for law. regardless of what constitutional interpretive methodology you ascribe to, I think there's a compelling case that the 14th Amendment's protections extend to the unborn, and that the Constitution, in fact, prohibits states from legalizing abortion. Now, from a living constitutional perspective, the story of our Constitution is the story of expanding more rights to more and more members of the human family based on our broadening notions of dignity and equality. And on that view, the violence of abortion is incompatible with the evolving standards of decency that mark the progress of a maturing society. But in this talk, I'm primarily going to argue from an originalist perspective, which is to say on Justice Scalia's own terms. Why? Well, in addition to it being representative of my own view, nearly half of the Supreme Court and most of the justices who would likely vote to overturn Roe are to some degree originalist in their methodology. That is, they want to ascertain the original meaning of the constitutional text and apply it faithfully. So if you'll accept that minor premise that the preborn child in the womb is a member of the human species as a medical and scientific matter, all that must be demonstrated is that the term person in its original public meaning at the time of the 14th Amendment's adoption applied to all members of the human species. So I'm going to draw on three strands of evidence to support that conclusion. First, dictionaries of common and legal usage at the time of the 14th Amendment's adoption define the terms person and human being interchangeably. The original public meaning of the term person included every member of the human race. Furthermore, the use of the term person in statutes and court cases at that time referred specifically to the unborn in many instances. Second, centuries of common law precedent and state practice leading up to the 14th Amendment's adoption in 1868 indicates that the unborn were considered legal persons. And third, the authors of the 14th Amendment expected it to protect every human being, especially the weakest and most marginalized. Now, that original expected application isn't conclusive of the original public meaning, but it is indicative, and it demonstrates that informed citizens believed that the text of the 14th Amendment applied to every human without exception. So I'll address each of those points in turn. First, let's start with the text. Dictionaries of common and legal usage at the time of the 14th Amendment's adoption treated the word person as interchangeable with human being or man. For example, the 1864 edition of Noah Webster's Dictionary of the English Language defined the term person as relating, quote, especially to a living human being, a man, woman, or child. The entry for human includes those belonging, quote, to the race of man. And no dictionary of the era referenced birth or the status of being born in its definition of person, man, human being, or child. In legal usage, the term person had extensive scope. Alexander Burrell's New Law Dictionary and Glossary defined person as a human being considered as the subject of rights as distinguished from a thing. So here we have a natural person. And that's consistent with Blackstone, for whom there was no distinction between biological human life on the one hand and legal personhood on the other. As part of his discourse on the rights of persons in his authoritative commentaries on the laws of England, Blackstone wrote that natural persons are such as the God of nature formed us, perhaps echoing the words of the psalmist in Psalm 139, who says of God, "You formed my inward parts, you knitted me together in my mother's womb." Blackstone declared that life is a right inherent by nature in every individual and begins in contemplation of law as soon as an infant is able to stir in the mother's womb. Now, as I explained in my article, this mention of the unborn child stirring was intended to protect prenatal life as soon as it could be discerned and not to exclude human life from protection prior to that point. So it's proper to derive the principle from Blackstone and others that if human life could be shown to exist, then legal personhood existed also. So now that we're equipped to understand the meaning of the word as it was used in 1868, and let's look at how it's used in the 14th Amendment. The opening phrase of the amendment says, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." So you'll notice that this language doesn't define the scope of the class persons. Rather, born or naturalized and subject to the jurisdiction thereof serve to narrow that broader class of persons to which the term refers down to its narrower subset of citizens. Prior to the adoption of the amendment, foreign nationals and Native Americans, for example, were considered legal persons. And in fact, the term person has always been larger than its subset citizen, and the Supreme Court's longstanding interpretation of the 14th Amendment in cases like Yickwo versus Hopkins reflects that traditional understanding. So when Justice Blackmun took an intratextual approach in Roe and concluded that the word person has, quote, application only postnatally, he drew an unsupported conclusion from the text. Justice Blackmun went through all the times that the word person is used elsewhere in the Constitution to try and figure out what it meant in the 14th Amendment. But as Yale law professor Akhil Amar has pointed out in his article on intratextualism, it's very difficult to prove what a word can't mean through negative inferences alone. So to illustrate the problem, you could draw an opposite and perhaps equally unsupported conclusion from the text through the use of the phrase persons born or naturalized in the citizenship clause that we were just discussing. You could say that the adjective naturalized indicates that there are persons who are not naturalized, and that if born functions in the same way to limit the category of persons eligible for citizenship, it indicates that there are persons who are not born. I think that argument is just as defensible and at least as plausible as the intratextual argument that Blackmun makes. Now, before we turn to the next line of evidence, I want to point out that at this point, I think my case is proven. The term person in 1868 definitively included all human beings. And whether states historically believed that the unborn specifically were members of the human species doesn't necessarily matter as long as they believed all human beings were entitled to protection under the 14th Amendment. So to borrow from Justice Scalia here, just as freedom of speech protects movies and internet communication under an originalist interpretation, even though those technologies didn't exist at the time of the First Amendment's adoption, person protects every member of the human species, regardless of whether individuals were recognized as members of the human family at the time of the 14th Amendment's adoption. So the meaning of the relevant text doesn't evolve. It's simply applied to a new set of circumstances or new information. And in fact, I think this is actually a stronger case than a situation in which one applies an old textual provision to a new technology that didn't exist at the time, because here we're interpreting the text as applied to the same object, just with better information about the nature of that object. As it turns out, though, the states did historically believe that the unborn were living members of the human family. And that leads me to my second line of evidence, which is the common law precedent and state practice with respect to abortion. The English common law tradition, which the United States inherited and developed after its independence, consistently treated abortion as the wrongful killing of a human being. Abortion was prohibited as soon as life in the womb could be detected. Prior to the advent of modern medical science, though, unborn life was detected at quickening, that is, at the first perceived fetal movement. And that was a useful evidentiary tool for determining whether the crime of abortion had occurred, because there was actually great difficulty in proving the essential element of abortion, that the child was alive prior to quickening. And proving that the child was alive was necessary to proving that crime. So legal giants such as Lord Coke and Blackstone formalized the legal principles protecting prenatal life, which were eventually passed on to the American colonies and adopted into their state common law systems. When embryologists discovered in the 1830s that each human individual begins his or her life cycle at fertilization, the states rapidly began to discard the obsolete quickening standard in favor of new medically accurate fertilization standard. So for example, the Pennsylvania Supreme Court ruled in 1850 that, quote,
That's not just me, right?
yeah, sorry, I think I dropped there. Are you guys there? Can you hear me?
I can now, yes.
Apologies about that. I think my internet's a little bit slow here.
You're back now though, Josh, I think.
Okay, well, if you can hear me, great. Well, I was just talking about the national mood regarding abortion in that era. And I wanted to bring up the 1851 case, Smith versus State, in which the Supreme Judicial Court of Maine also upheld a statute that discarded that old quickening standard in favor of the new information. So by the time the 14th Amendment was ratified in 1868, the states widely recognized unborn children as persons. 23 states and 6 territories referred to the fetus as a child in their anti-abortion statutes. 28 listed abortion among their statutory offenses against the person, or a functionally equivalent classification. In a particularly striking example, the same Ohio legislature that ratified the 14th Amendment in January 1867 passed legislation criminalizing abortion at all stages and just 3 months later in April. The committee that reviewed the bill actually was composed of several senators who had voted for ratification of the 14th Amendment, and they declared in their report that abortion at any stage of existence is child murder. So strong words. Now, some scholars like Yale law professor Reva Siegel have suggested that this trend was motivated out of concern for women's health or distrust of women's reproductive choices, or even to protect the medical profession from unlicensed practitioners. But this view is inconsistent with the fact that anti-abortion statutes during the period actually increased the penalty for abortion if it were proved to have caused the unborn child's death. And actually, a majority of states did so irrespective of the age of gestation. So Maine, among other states, deemed prosecution for abortion fatally defective if it didn't allege the destruction of the child. In any case, the historical context of abortion at common law and its treatment in the years just prior to the adoption of the 14th Amendment provides strong evidence that the public meaning of the term person included the preborn. Now, the third line of evidence I want to briefly consider is the amendment's anticipated application. So the framers of the amendment themselves certainly thought that their amendment required due process and equal protection of every human being. And while the intentions of the drafters of the 14th Amendment don't directly govern the meaning of the text, it's worth wondering whether a radically inclusive amendment can be reasonably interpreted to exclude a subset of individuals who are considered human beings at the time it was written, and who we now know more than ever are part of the human family. The primary framer of the 14th Amendment, Representative John Bingham, believed the amendment prevented states from refusing, quote, any of the rights which pertain to common humanity. Senator Jacob Howard, who sponsored the amendment in the Senate, emphasized that the amendment guaranteed even the lowest and most despised members of the human race equal protection of the laws. During the congressional debates, Representative James Brown rhetorically asked, does the term person carry with it anything further than a simple allusion to the existence of the individual? So the drafters of the amendment carefully crafted this text to include all human beings within the Constitution's jurisdictional reach, regardless of their origin or circumstance. As Justice Hugo Black later put it, the history of the 14th Amendment proves that the people were told that its purpose was to protect weak and helpless human beings. Their widely shared beliefs shed light on the amendment's public meaning at the time of its adoption. The 14th Amendment was meant to be a new birth of freedom for all human beings. So what does this mean for our current regime of abortion on demand through all 9 months of pregnancy, as established in Roe v. Wade and Doe v. Bolton, and reaffirmed in the Casey versus Planned Parenthood decision? Well, in his Roe majority opinion, Justice Harry Blackmun acknowledged that if personhood is established, the case for a constitutional right to abortion collapses, for the fetus's right to life would then be guaranteed specifically by the amendment. Under an originalist interpretation of the Constitution, I think the edifice supporting Roe and its progeny crumbles. So given the original public meaning of the term person, the contemporaneous anti-abortion statutes that were purposed to protect prenatal life, and the public explanations given by the framers of the 14th Amendment about its scope of meaning, I think the historical evidence supports extending protections to prenatal life on originalist grounds. You might be wondering though, where's the state action here? Even if the unborn are included within the meaning of the term person, how can it be that there is state action that would make the 14th applicable here? Well, as you know, a state's failure to protect an individual against private violence doesn't typically constitute a violation of the Due Process Clause. You might recall the DeShaney versus Winnebago County case from con law as an example of that principle in action. But the DeShaney court qualified its holding by recognizing that the state may not, of course, selectively deny its protective services to certain disfavored minorities without violating the Equal Protection Clause. So if constitutional protections for the unborn were acknowledged, a state couldn't refuse to prosecute the intentional killing of the unborn while continuing to prosecute the killings of other classes of persons without violating the Equal Protection Clause. In light of the evidence, the Supreme Court should reverse course on abortion. But even if you're convinced of all this, so what? Maybe a bare majority of the current court is identifiably originalist in their interpretive method, and even those who ascribe to originalism might oppose taking such a bold approach. So in that case, what's the path forward for extending constitutional protections to the unborn? I think that every branch and level of government has a role to play. First, Congress should act under Section 5 of the 14th Amendment to enforce by appropriate legislation the Constitution's protections for unborn persons, such as through the Life at Conception Act. The executive should follow Lincoln's example to assert his departmental authority to interpret and uphold the Constitution. The president must fulfill his constitutional duty to take care that the laws be faithfully executed. And this may and should include, in my view, a rejection of judicial supremacy and the idea that Roe v. Wade is the law of the land. I don't want to get bogged down too deeply on that point because it's not the focus of my scholarship, but I've written a little bit on this topic. If you Google the Lincoln proposal, you'll see what I have in mind. I think it's important to understand that the president swears an oath to preserve the Constitution of the United States and not every pronouncement of the Supreme Court. And I know Ed agrees with me on that point in particular. Finally, the states retain their primary duty to protect the inalienable rights of all human beings within their jurisdictions, the foremost of which is the right to life. So I think states have a responsibility to exercise their police powers, that is, their powers to promote public health, safety, and morals to prohibit abortion. State governors and legislators, I think, should do everything in their power to uphold the United States Constitution on this point. And I think that various personhood initiatives in states have been an encouraging trend in that direction. So I hope we continue to see that effort play out. Until the Supreme Court, the people or their elected representatives undo this caste system of separate and unequal treatment for preborn persons, I don't think there can be true equal protection for all under the law. And that's why I believe that the legal regime that discriminates against preborn human beings should be abolished on originalist grounds, restoring the harmony between science and law in a manner that's consistent with the Constitution. Thanks so much for your time listening to me today, and I look forward to the thoughtful comments from Ed.
Well, thanks very much, Josh, for that excellent presentation. I'm in the unusual position, I think the first time ever in my life, of arguing the more pro-abortion side of an argument. Just to lay my cards on the table, I have been a vigorous critic of Roe for a long, long time. I actually clerked for Justice Scalia during the year at Planned Parenthood versus Casey. That was a searing experience. I think that Roe stands with Dred Scott as among the most infamous decisions in the Supreme Court's history. In both cases, you had a lawless power grab of the Supreme Court that prevents Americans from protecting the basic rights of a whole class of human beings. I am in broad agreement with much of what Josh had to say, certainly on the biological status of the unborn human being, also on the moral status, and also I view abortion as a very serious moral crime, as I gather Josh does as well. And I want to say too that Josh's case is much stronger than I had realized. I had run across versions of this argument years and years ago. I think, frankly, in defense of Justice Scalia, I think he had run across some years and years ago that were like barely fleshed out and much weaker than the case that Josh has presented. Josh at one point said he was going to present a plausible case and then move to compelling. I would put his argument somewhere between plausible and compelling. I think it's somewhere in the middle there. And I will say it is about 1 million times more persuasive than Roe. So in a healthy society that engaged seriously in constitutional debate, the debate would be the debate that we're having. This would be it. I'm going to present what I see as the main argument against Josh's position. I have smaller issues with some of the arguments he presented, but I'm going to present what I think is the main reason why I'm not persuaded. And that really, my basic argument is that if you look at how persons is used in the 14th Amendment itself, in Section 2, you see that representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. And that provision itself modifies a provision in the original Constitution, which says that the respective numbers in the state shall be determined by adding to the whole number of free persons, including those bound to service for a term of years and excluding Indians not taxed, 3/5 of all other persons. And so if it were clear in 1868, when the 14th Amendment was ratified, that persons in its legal meaning included the unborn, there should have been an insistence on trying to count unborn human beings for purposes of apportionment. But not only was there not any such effort, so far as I know, but you also had these 80 prior years in which the language of the Constitution, under the same argument, would have dictated that you count the unborn in the apportionment provision. I haven't seen any argument that was ever even raised as an issue. Although one could imagine that that some states would have seen, some advantage, minor as it might be, in making such an argument. Now, look, I know there are arguments about administrability and convenience about why that wasn't done, but I find it striking that, again, so far as I know, it was never even raised as a possibility. And so, we do have the phenomenon that the 14th Amendment was ratified at the very time that the common law prohibition on abortion was being codified in statutes in so many states. And that, to me, is just a killer argument against Roe. No play on words intended there. But I don't think it establishes what Josh maintains that it establishes. In fact, I think, when you look at the ratification history, of course, you see all these references to, and Josh had beautiful quotes about protecting the most vulnerable. I forget exactly what the quotes were, but I haven't heard anything to suggest that anyone understood those to be references to the unborn. So that is my major. That argument is what I see as the going to the major defect in Josh's argument. There's some methodological questions involved in original public meaning that different people take different positions on, and it could also affect where you end up on this question. One basic issue is, what's the standard of proof? What level of certainty do you need to establish in order to have the judiciary override the democratic processes? My own view, contrary to a lot of libertarians, is that you need a very high standard. But in fairness to Josh, those who say that no, a lower standard is appropriate, including that there really is the approach of libertarians, I think Josh's argument has to be taken far more powerfully by them if they're going to accept a lower burden of proof. The role of expected applications comes in here as well. Josh made some reference to that. I think that the original expected applications are silent regarding a right to life, the life of unborn human beings. I mean, again, Josh has come up with particular phrases that can be read capaciously to cover the unborn. But again, I see nothing. I've heard about nothing about the statements that makes you think, aha, this is what it was being referred to specifically. I'll address finally Josh's proposals for the other federal branches of government and states to act in this area. And one big question here is, what is the scope of Congress's authority under Section 5 of the 14th Amendment? The Supreme Court has taken a very narrow, I think probably an unduly narrow view of that authority. And among other things, the case of the city of Bernie v. Flores, where Congress's ability to enforce doesn't allow it to act prophylactically in any meaningful way. I question whether the city of Bernie v. Flores is rightly decided. And I think that, that there may be a better reading of the 14th Amendment that understood the amendment as aimed in many ways at the Supreme Court's power grab and Dred Scott. And it's saying, no, we're not going to court as the lead actor in defining this. Congress has broad authority to put it into force, to enforce it. And under that view, I think there's ample room for Josh's proposal that Congress define under Section 5 the term persons broadly to include the unborn. So I emphasize that there are lots of other folks who would make lots of other arguments against Josh, arguments that I just don't buy into, arguments about how, that quickening was the test of common law, and that's, how can you go beyond that? Of course, these are the same people who don't accept quickening as any acceptable measure. Quickening happens. Correct me if I'm wrong, Josh, but actually, I should know this from my daughter-in-law, who has our grandchild in her womb. Quickening happens, 12 or 14 weeks, whereas viability, the standard of the Roe, is more around 20 to 24 weeks. Obviously, it's changes with technology. So, the very people who would say, "Oh no, common law is just quickening," don't accept that as a standard. Of course, they're not originalists. They embrace this living constitution, which is nothing more than an excuse for judges to impose current elites' preferences. And again, first of all, I think Josh makes a very strong case on original meaning grounds. But beyond that, if you talk about living constitution, his case for a right to life on living constitutional grounds is far stronger than Roe. I mean, we've learned so much about the nature of prenatal life, and so I want to congratulate Josh. Again, I think it's a powerful argument that opened my eyes. I hadn't realized how strong, in so many respects, the legal meaning of a person had been. And in defense of Justice Scalia, again, I don't know that argument had been made very well to him either. So with that, I'll open things up. Invite Josh to answer me back, and then I think we're going to open things up for questions.
Yeah, that sounds great. I think your first comment about Section 2 apportionment, I think, is actually one of the biggest difficulties for my theory. So I'm glad that you brought it up. It's an interesting question. This is a research question that I'd like to look into further, because I'm not aware of any census information where, preborn children were counted in the census or anything like that. There have been a few cases that arose in district court that addressed this issue, but unfortunately they were after the Roe v. Wade decision. So the courts just dismissed the case and cited to Roe. I do think on policy grounds, it's not clear that that they should be excluded from the census, but as an originalist matter, I think it's a difficulty, and it's one that I want to research more. As far as the ratification history, I think I mentioned some of the kind of broad statements. I think when you're looking at the ratification history of the 14th Amendment, I think it's difficult to require, specific intent from the framers of the amendment when the text itself and the public meaning of the text is broader. So I guess my view is that even if the, framers of the amendment didn't have abortion specifically in mind when they were drafting this text, if you had asked them about it, they could, and maybe they thought it through, maybe they would have come to this conclusion. But kind of regardless, I think it might be too high of a bar to require specific intent. And in fact, certain statements from the framers of the amendment, suggested that it wouldn't result in overturning state anti-miscegenation laws, or wouldn't result in the desegregation of schools. And obviously the text seems to be a little bit broader than that, I think, even on an originalist argument for those positions. So I think my bar, at least on what the specific intent of the framers of the amendment was, is perhaps a little bit lower than what Ed has suggested. And then the last thing is on the standard of proof. I think that's an interesting point, and I think that's an important point for originalists. What level of certainty do you need to have for the judiciary to override the democratic process? And I think that this is something that Scalia obviously cared deeply about as well, the democratic process. But I do think, especially when you look at the the originalist evidence in combination with the whole purpose of our, what Lincoln was so good at doing, looking at our Constitution as, the frame of silver around the apple of gold of the Declaration of Independence, and the idea of the Declaration of Independence that all men are created equal and endowed by our Creator with certain unalienable rights, the foremost of which is the right to life. I think that, when you step back and look not only at the originalist evidence, but the grand scheme of our republic and the order of our Constitution and how it fits in with the Declaration, I think it's difficult to defer to democratic process when we are dealing with that endowed right of the right to life. So I think that's all I have to say there. I think I'm in general agreement with Ed on the Supreme Court's kind of cramped view of the enforcement power that Congress has under Section 5. But I think we're in general agreement on that. So with that, I think we're open for questions, and I look forward to hearing from some of the law students.
So I'll start with the question while people go ahead and drop their questions in the question and answer feature. So I'm curious whether, this is for both panelists, what you think the best vehicle meaning a court case, what question would that court case have to present to overturn Roe? Now, as a little bit of a backdrop, I know a lot of people are very critical, and maybe rightfully so, of the strategy that anti-abortion, pro-life litigators take in litigating abortion cases, in that they never ask the court to overturn Roe. So I'm just curious what both of you would think about that, and whether the differences in opinion that you have on the original public meaning aspect would change your opinion at all.
Well, look, I think the sooner the better, and I think we should stop being timid. If it doesn't happen now, it's never going to happen. Any case that involves abortion regulation presents the opportunity for the threshold question: what's the standard of review for this abortion regulation? We now have broadly speaking, a 63 conservative majority. There is never, you can not expect there ever to be a better time to overturn Roe, restore the matter to the political processes, let them work it out. Obviously, I'm assuming my answer to the debate question, talking about returning things to democratic processes, but I don't think Josh disagrees that the court would not go beyond overturning Roe to adopt an anti-Roe. And then, I would hope that this issue that has disrupted and distorted American politics for coming up on 50 years now, and people would realize, okay, for better or worse, we're handling this through the democratic processes. And you've seen in recent years, again, I hate the laws, but you've seen what New York and Massachusetts have done. You've seen what's happened in other states. We can handle this, and better yet, when you work things through the political processes, everything is provisional. It can be revisited. We can learn from this. Both sides can learn and adapt. There's a case right now, to answer your question specifically, before the Supreme Court. Mississippi v. Dobbs, I believe, is the name. The court's been sitting on this for a long time. I've argued, look, take this case, use this to overturn Roe. I'm forgetting now, Josh, you'll know it. This involves, I believe, is this a 15-week?
15 or 18. I'm having trouble remembering what it was.
Yeah, it's 15 weeks, which incidentally, for all those who want to look to international law to decide what the Constitution means, 13, 14, 15 weeks is a standard in much of Europe. Sorry to cut you off there, Josh.
No, I think that's exactly right. I mean, I think any of these cases could present this question, and regardless of whether the court decides to return the issue to the states or go further, I think it would present the question. So I'm encouraged by the state legislation and the litigation that I've seen. I recently saw a bill that's making its way through Arkansas that would actually prohibit abortion, and I think that would present a perfect test case for this. But anything that would go beyond the Casey or Roe current framework, could tee this question up.
Cool. And I'm going to ask one more follow-up, and then we'll get to the audience Q&A, just because I'm curious. This is specifically for Ed. I'm so curious what you think about this. So, in light of Roe and Casey being the law of the land,
not the law of the land. The Constitution is the law of the land.
Right. Well, I agree with you on that.
Well, that's what the Constitution itself says. So, sorry, this is one of my pet peeves when the court decides a case, and senators don't want to face the issue, say, "Oh, the court has spoken. It's the law of the land." No, it's not.
So, I guess my question is, given Justice Thomas's views on stare decisis, and that something would need to be demonstrably erroneous before we would overturn it, would you view the court overturning on Josh's theory as legitimate in any view of stare decisis?
Well, you don't need to get to Josh's theory to overturn Roe. Roe is demonstrably erroneous. Now that leaves the question of what replaces Roe, whether this is a matter left to the states, or as Josh says, that broadly, at least, states have an obligation to prohibit abortion. I believe Josh would say that equal protection principles would allow life of the mother exception that's analogous to self-defense in other contexts. But I think the standard for overturning is easily met. Have in mind, of course, Justice Thomas is, he says it's enough that it be demonstrably erroneous. He's taking given less weight to stare decisis than the traditional multi-factored, malleable, meaningless test. I think that it's easily met here.
Awesome. Okay. So I'm going to turn to audience questions now. Samuel identified something that I kind of picked up on too. Now, don't take this as any criticism of your theory, Josh, but I know a lot of people would think of this and then immediately think of Bostock and this kind of, Congress passed Title VII in the 60s, and they didn't really know that it included this, but nevertheless it did. And we're just so much wiser and smarter now, and we're able to figure that out. So I'd just be really curious to hear you distinguish your argument from Bostock. I think you kind of already hit on it a little bit, but if you wouldn't mind returning to that point.
Yeah, I mean, I think there's a number of problems with Bostock, from analytically and metaphysically, but at least analytically, it seems like the on the basis of sex language was just removed and analyzed in isolation, essentially, from not only what they would have thought it meant at the time, but also what it actually means today. I think there's a lot of problems with Bostock that just analytically the opinion is unsatisfying, and so I disagree. I think my presentation, I don't think we're pulling the word person out and looking at it, in an abstraction away from the rest of the history of the text. I firmly think it should be interpreted within the rest of the text and the history. And I happen to think that the text and the history support my view. So, I generally agree with Justice Alito's kind of critique of the textual approach taken by the majority opinion in Bostock. And that's, I guess I just don't see it as being comparable.
I entirely agree with Josh on that. I think Bostock is an awful opinion in so many ways. And whatever critique I've offered of Josh's article, his argument is again magnitudes better than the terrible argument that the majority made in Bostock.
We have another question. This is also from Samuel, and it's for Mr. Craddock. So in Roe, the court noted that some states that criminalized abortion didn't punish people to the same extent as states punished other murders. So it suggests that this shows that states didn't actually view unborn children as full persons. How would you respond to that argument? And then I have a kind of related follow-up question when you're done.
Yeah, so I addressed this actually in my article, and I think that this is not a it doesn't have any indication for the personhood of the victim. So for example, we have legal principles like where there's aggravating and mitigating factors, right? So if you kill a police officer, for example, that could be an aggravating factor, right, in sentencing. But it's not a statement about the value, like we think that police officers are more persons than other victims of homicide, right? And so I think that there are legal principles where, out of concern for the situation of women in these sorts of situations, that sort of thing, that we might have it as a mitigating factor, right? And that's historically the way that they viewed this, why it was treated differently. And so I don't think it's in any commentary on the value of the personhood of the victim. And I think historically, you see that in pretty broadly throughout the criminal law, where you have these sort of judgment calls based on the situation rather than the inherent worth or dignity of the victim.
And then in a similar vein, under this theory of the 14th Amendment, would say a state law which explicitly allowed pregnant women to drink or smoke, which we know is harmful to the unborn, would that be unconstitutional?
I think it's important. I think even if you accept the position that the preborn child is a person with constitutional rights, preeminently the right not to be killed, I don't think it entails the view that the law has to prohibit all actions that could plausibly expose the preborn child to risk of unintended death, right? So there's lots of things that are risks, but don't rise to the level of an intentional killing of a human being, and I think that's really what is would trigger the equal protection concern that I have, because all states have homicide laws that generally prohibit the intentional taking of a human life, and to the extent that states systematically decline to enforce those laws when the victim is unborn, I think that's what triggers that equal protection principle. So I think even if you accept my argument, you don't have to, and I don't think it entails the view that it has to prohibit all actions that could potentially risk the life of an unborn child.
Moderate amounts of alcohol are fine for mothers. I don't know what the evidence is on tobacco.
Kyle, I'm going to cut in and ask a question real quick. I'm just curious. So, Josh, do you think that unborn babies should be counted in apportioning representatives? To Ed's point,
and you're asking I think as a textual matter, I think I would be pretty committed to the view that. So anyone interested in this question should read the briefs in the recent Trump v. New York case, which was a case about whether undocumented immigrants, illegal immigrants, should be counted in the census. There was a lot of interesting historical argument about the scope of persons counted and whether they qualify as inhabitants. I'm operating, I haven't done the full research on this, but I'm operating on the understanding that preborn persons would qualify as inhabitants for census purposes. But again, I haven't researched this question in significant depth. And I think at least, so that's the kind of the textual matter. I think I would have to be generally committed to that proposition. I think as a policy view, it's not a crazy position either. I mean, under current law, a baby born prematurely at 22 weeks is counted in the census, right? While a preborn baby at 9 months gestation isn't counted, even though the preborn child is actually older, healthier, and perhaps more likely to survive into adulthood. So it seems to me that the preborn could be counted. I mean, the policy argument against it is that, some preborn lives may end prematurely due to miscarriage or stillbirth. But, again, we count individuals in hospice care who are expected to die imminently. So I guess I'm just not particularly persuaded, since it seems to be clear to me as a textual matter with the, and I haven't done the historical research, but as a textual matter. And I guess it just it makes sense to me to be able to count preborn children for apportionment purposes, since those children are likely to remain residents of the district and receive services in that district. So I as a textual matter, I think it's probably right to do that. And as a policy matter, I think it's not crazy.
Let me follow up on that. What about, 10,000 frozen embryos, in the freezer somewhere? Again, a horrible thing that exists, but
yeah. No, it's a great question. I mean, I think that, right, they would qualify as persons. And that raises a lot of questions. I mean, I think it is a problem that we've allowed that to happen. I don't know that means that they shouldn't be counted for apportionment purposes. But again, I mean, it's, this is something that when people were thinking about apportionment, never would have considered that we would have the possibility of creating human beings and storing them indefinitely in freezers.
Right, and then if you start counting them for apportionment purposes, you're suddenly going to have a terrible, race to the bottom in terms of, right. Which state can, store up more. It's gruesome.
Yeah, and I think you and I would both agree that, I would want to see more regulation on this issue, and I think that actually the, equal protection clause might prohibit, IVF clinics from just discarding embryos that they create when they create excess numbers of embryos. Just throwing them away, I think would be, probably an equal protection problem as well. But yeah, I agree that, you don't want to create bad incentives here. And I would hope that, I think that we need much stronger regulation in this area.
Hey, Josh, your argument might actually have, broader implications for IVF. It may be that, simply even not discarding, but even storing these embryos in freezers would present a real problem. I'm making that as an observation, not as an argument against your position.
Right. Yeah, I'm not sure. I think acknowledging the personhood of the preborn, I'm not certain I don't think it would prohibit IVF. I think it would simply require IVF clinics to reform their practices to respect the life of the embryos they've created. I don't think they would be able to, create dozens of embryos and then discard and kill the unused ones. Practically speaking, many European countries already have regulations that only permit fertilization of embryos that would actually be implanted in the uterus. And so I think it can be done without killing unused embryos and in a way that, wouldn't be prohibited under my argument.
Well, I made this comment to Josh privately, and we're just kind of spitballing here. What about a deprivation of a liberty interest to the embryo at that point?
Yeah, it's a good question. I mean, I think that, so just taking a step back, children's rights have always been, constitutional rights have always been circumscribed, right? So children, generally speaking, have very little liberty interests. You can't bring a claim against your parent, a constitutional claim against your parents because they won't let you go to the movies, right? That's not a liberty interest claim. And so they've always been tailored to the capabilities and the capacity of the person exercising them, particularly when it comes to children. So I don't really think that you would have any sort of liberty claim for a preborn embryo. I just don't think that would make any sense, or it's hard to imagine that any claim would even be possible. I think that a life claim, that makes sense. Property claim, actually, historically, unborn children have been appointed, or guardians ad litem have been appointed for unborn children, specifically to protect their property interests, for example, in inheritance law, particularly where they might have a conflict with the parents involved, a conflict of interests. So I think life and property, it kind of makes sense to have those sorts of claims. I just don't think liberty makes any sense to have, any sort of claim there.
Well, we're just about at time, so I will give one last question, and this is just purely speculative, so you don't have to answer it if you don't want to, Josh. How many of the court's conservatives do you think you can get with this argument?
I'm not terribly optimistic on many of them. I think Justice Thomas is probably my best bet, but I'd love to get some of the other, if I'd love to sit down with any of the justices for an hour and just have a conversation about it. So see if I can persuade them.
Cool. Well, if either of y'all would like to have a last word.
Well, I'll just say what I said at the beginning. I think Josh's paper is much stronger than I expected. And I encourage you all to read it. Law Professor Mike Paulson also has an excellent piece, I think back from 2012 or so, which I somehow had never run across. Yeah, again, I congratulate him both on a great presentation here and on a powerful paper.
Yeah, and thank you, Ed, for your helpful commentary and for pointing out some of the weaknesses in my argument. And I hope that everyone listening has enjoyed and will be intrigued and motivated to look into this further for themselves.
We're very thankful for both of y'all's time. This has been a good event. As we're closing up here, Mike again dropped the registration link for next week into the chat. So be sure to fill that document out on your way out of here. But otherwise, we appreciate both of your speakers' time, and we hope you all have a good weekend.